Persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention.
Landmark Cases, C-SPAN's Special History Series, produced in partnership with the National Constitution Center, exploring the human stories and constitutional dramas behind 12 historic Supreme Court decisions.
Mr. Chief Justice, and may it please the Court.
Quite often, and many of our most famous decisions are ones that the court took that were quite unpopular.
Let's go through a few cases that illustrate very dramatically and visually what it means to live in a society of different people who help stick together because they believe in a rule of law.
Good evening and welcome to C-SPAN's Landmark Cases. Tonight's case is Katz versus the United States. It's a 1967 case, and the person who gave his name to the case is somewhat of an unlikely hero. He was a bookmaker specializing in college basketball games, and he took his wiretapping case to the Supreme Court and in a 7-1 decision expanded our privacy rights under the Constitution. We're going to learn more about his story and the significance of this case over the next 90 minutes. But we're going to begin by listening to Justice Samuel Alito in his confirmation hearings where he talked about the importance of the Katz case. Let's listen.
Sometimes changes in the situation in the real world can call for the overruling of a precedent. An example of that is provided by Katz versus United States, which I was talking about this morning in relation to wiretapping. The old rule under Olmstead was that in order for there to be a search, you had to look to property law. You had to see whether there was an invasion of a property interest. And then with the development of electronic communications and electronic surveillance, wiretapping, or other forms of electronic surveillance, which is what was involved in Katz, the Supreme Court said that this isn't a sensible way to apply the Fourth Amendment principle under the conditions of the modern world. And they said famously that the Fourth Amendment protects people, not places. So they found the doctrinal underpinnings of the old Olmstead rule to be undermined by developments in the society, and they shifted the focus from property law to whether somebody had an expectation of privacy.
So our two guests at the table are going to unpack that story for us tonight. Let me introduce you to them. Jeffrey Rosen is the president and CEO of the National Constitution Center. The Constitution Center are our partners in this Landmark Cases series this time and in the first round in 2015. He is also the author of numerous books about the law and the court. His latest is a biography of William Howard Taft that's just been released. Jeffrey Rosen, thanks for being with us tonight.
So great to be here, Susan.
Jamil Jaffer is the founder of the National Security Institute and director of the National Security Law and Policy Program at George Mason University's Antonin Scalia Law Center. He clerked for Neil Gorsuch twice in the federal court system, and former counsel and advisor to the Senate Foreign Relations Committee and the House Intelligence Committee, and also President George W. Bush. Thanks for being here tonight.
Thanks for having me.
So as we begin, Jeffrey Rosen, we worked with you on selecting these cases, and this was the one you wanted to do. Why is this case interesting to you?
Because it's maybe the most important privacy case of the 20th century. As Justice Alito said in his confirmation hearings, this was the case that repudiated the idea that you needed to have a physical trespass to trigger the Fourth Amendment. It was the general warrants and writs of assistance that sparked the American Revolution, but in an age of electronic technology, it made no sense to say that you had to trespass on private property in order to have an unreasonable search of our persons or electronic effects. And by declaring that the law protects people, not places, the court set the stage for moving the Fourth Amendment into the electronic age, and that's precisely the debate that we're having today.
You have spent much of your recent career kind of focusing on national security law. Where does Katz fit in that pantheon? How important is it?
Well, I mean, Katz is the central case, as Jeffrey just laid out, for how we think about the Fourth Amendment, how we think about the Fourth Amendment in surveillance. And one of the key issues in national security law today is surveillance and how the government conducts surveillance. It's a topic of much debate. After Edward Snowden's revelations, it was a topic of new legislation in Congress. And there continue to be debates today at the court, even this term, are two major cases involving, well, at least one involving electronic surveillance and two involving the Fourth Amendment. And so it continues to be very much a hotly debated topic at the court and in our political system.
Well, we need to spend some time just on the Fourth Amendment itself, so I'm going to put the language of it on the screen. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So, Jeffrey Rosen, a bit of a history lesson. What were the founders thinking, and what gave rise to this amendment?
So Chief Justice Roberts has quoted the speech of James Otis in 1763 denouncing the writs of assistance. And John Adams said, at that moment, the child revolution was born. So that's how important this historical story is. And the writs of assistance and general warrants allowed the king's agents to break into people's homes, searching for evidence of the fact that they hadn't paid the hated tea taxes or had published anonymous seditious pamphlets criticizing the king. And the general warrants didn't particularly specify the places, but just said, go find the authors of these pamphlets or go find the people who didn't pay their taxes. So there were instruments of tyranny that allowed the agents to rummage through places indiscriminately. And by striking down the general warrants as tyrannical, common law courts established the principles that were embodied in Revolutionary-era state constitutions. The Massachusetts Constitution of 1780 has a longer version of the Fourth Amendment, and when James Madison drafted the Fourth Amendment, he cut and pasted from those state constitutions to make clear that you couldn't have searches that don't particularly specify places to be searched and the person or things to be seized.
You teach the Fourth Amendment. What do you tell your students about what its importance is?
Well, it really is, I think, at the core of our civil liberties, right? It really protects, as Jeffrey said, against these general warrants and the tyranny of the king. I mean, remember, our framers came from a place of deep suspicion of overweening federal or governmental power. And so when they built our system of governance, they built a federal government of limited powers, and then they laid out the specific rights that the people were entitled to. And one of the core rights was the right to be protected against these unreasonable searches and seizures.
We will get to calls and your tweets in about 10, 15 more minutes, and let me tell you how you do that. If you're watching us in the Eastern or Central time zones, 202-748-8900. If you're watching us in the Mountain or Pacific time zones, 202-748-8901. And send us a tweet. It's C-SPAN, and use the hashtag landmark cases. And there is, as there has been each week, a discussion already underway on our Facebook page. You can be part of that now or after our program is over if you'd like. So as we get into the particulars of this case, there are a couple of personalities that people will hear about as we proceed. One is Charles Katz himself. What can you tell us about Charles Katz?
Well, you know, a consummate gambler, as you described, as you pointed out, a leading basketball handicapper in the United States. He had residences in New York and Los Angeles at the time of his arrest. He was living in a hotel on the 8200 block of Sunset Boulevard, the famous Sunset Strip, famous for many rock bands, all sorts of things. And he used to stroll down the street to a set of 3 phone booths that were right on the street in order to conduct his interstate gambling mission. And the FBI got wind of this, and that's what led to this case, was the wiretapping, or well, the surveillance of those phone booths when he went in there.
Some wags sent me a tweet last week that we have to explain what phone booths were.
That's true.
We don't have very many of them around anymore.
Yeah.
Harvey Schneider, who is he?
He's now a retired Los Angeles Superior Court judge, and he was the law partner of a guy called Burton Marks. And Burton Marks, we have to note, made a great filing in this case. When he filed the brief, he said, thanks to a typo, a man has as much a right to bet alone in a public phone booth as in his own home. So Schneider took over the case from Burton Marks, and it was Schneider who came up with the brilliant theory at the core of the case that rather than focusing on what's a constitutionally protected place, the question should be, borrowing from tort law, do people have reasonable expectations of privacy? Schneider remembered his own law school class where he studied the views of the reasonable man, and he made that argument before the Supreme Court, and it ended up defining the case.
So that must make both of you who teach law feel pretty good about the importance of individual classes and the impact that they can have on your students overall. This is one class that sparked a brainstorm for this lawyer as he was approaching the case.
Absolutely, and this is the most exciting sort of case to teach in criminal procedure because it does inspire people to transform the amendment and to translate it in light of new technologies. That was what Harvey Schneider did. That's what Louis Brandeis insisted the court should do. And that's what C-SPAN viewers should try to do with us tonight.
Potter Stewart, we're going to hear a bit more about the court overall, but he's an important character in this. Tell us a little bit about him.
So a Justice Supreme Court appointed by President Eisenhower, served in World War II as a member of the Navy Reserves, oftentimes found himself in dissent during the Warren Court era. But in this case, in the majority, writing perhaps a slightly narrower opinion than what Katz is known for. The Katz is really known for Justice Harlan's concurrence. So Potter Stewart had the majority and had the votes, but ultimately the really influential opinion to come out of this case was Justice Harlan's concurrence. You've referred to him and you've written the biography on him, but Louis Brandeis is not on the court in this time, but he's an important character in this case. Why?
Louis Brandeis wrote the most important privacy dissent of the 20th century, and I want viewers to go read it. It's in the Olmsted case, and you can get it online right now, although keep watching the show, so read it after the show is over. And Brandeis in Olmsted is dissenting from Chief Justice Taft's majority opinion. I love Taft very much right now and write about him in this book, but Chief Justice Taft had said in Olmsted, you need a physical trespass in order to trigger the Fourth Amendment, and that was a case involving wiretapping and another big bootlegger of his time. And there the wiretap was under a public sidewalk, so there was no physical trespass. Brandeis, in his amazing dissent, looks forward to the age of cyberspace and fMRI technologies and says ways may someday be developed by which it's possible, without physically intruding into desk drawers, to extract secret papers and introduce them in court. Brandeis said the right in question was the right to be let alone, and the amendment had to be translated to protect the same amount of privacy in the age of the wires as the framers took for granted in the 18th and 19th centuries.
We're in the era of the time when oral arguments are being recorded by the court. And so to give you the particulars of this case, we're going to listen. We mentioned earlier that the lawyer in the case was Harvey Schneider, and we're going to listen to him in the oral argument as he tees up the particulars and the facts in the case for the justices, and that'll help us understand the story that brings us to the Supreme Court. Let's listen.
Mr. Chief Justice, and may it please the court. The facts of this case that is now before the court are really quite simple. The law applicable is something else again. But the facts are as follows. Mr. Katz was surveilled by agents of the Federal Bureau of Investigation for a period of approximately 6 days. During that period of time, the surveillance was conducted by the use of a microphone being taped on top of a public telephone booth, or a bank of booths. There was actually 3 booths. One booth had been placed out of order by the telephone company and with the telephone company's cooperation. The other 2 booths were used by Mr. Katz. Sometimes he used one booth, sometimes used another. The tape was placed on top of the booth, or the microphone was placed on top of it by a tape. The FBI agents had undoubtedly read their homework and had not physically penetrated into the area of the telephone booth. Subsequently, after about 6 days of surveillance, Mr. Katz was arrested.
We have a period picture of the telephone booths on Sunset Boulevard that were really a character in this case. So could you explain the authority under which the FBI agents were operating at the time?
Sure. So, the FBI agents, their understanding was that, as Jeff laid out, that as long as you didn't invade the physical space of a constitutionally protected space, a home, or the like, there wasn't a problem. So they didn't bother to go get a warrant. They knew that they'd been watching Mr. Katz for a while. They knew it was his normal order of business to leave his hotel, walk down the street, take a stroll, enter the phone booths, make his bets in one of these 3 phone booths, or take the bets, I should say, and then wander off. So what they did was they put this microphone on top of the booths without invading them, and they set the microphones up so they could record what was happening inside the phone booths. And then as Mr. Katz would walk down, an agent would follow him, and they would send the high sign to one of the other agents, go to the booth, turn on the microphone so they didn't record anybody else. And then Mr. Katz would do his thing. And so the authority essentially was they weren't violating Supreme Court's decisions in penetrating a constitutionally protected space. So their theory is we don't need a warrant for this. And so they taped it, and that's how we ended up in court.
What law was he breaking? Is betting illegal? What about it was attracted the FBI's interest in the first place?
There are statutes involving money laundering, and there are also ones against betting. And I'm trying to get the exact one here. Here it is. This is thanks to the great National Constitution Center prep team. It's 18 U.S.C. 1804, a law against the transmission of wagering information by telephone. And it forbids betting or wagering knowingly using a wire communication facility for the transmission in interstate or foreign commerce of bets or wagers. So he probably was violating the law, but the question is whether the search, as Jamil well explained it, was constitutional or not. And if it wasn't, according to existing case law, the evidence had to be excluded, so everything turned on the constitutionality of the underlying search.
So what was illegal about it in the FBI's mind was that it was interstate.
Right.
If he had been making a local phone call, it would not have been so.
Well, if the gambling at least was local, it wouldn't have been used to the interstate wires. It wouldn't have violated federal law, and so that's how we ended up in federal court. In this case, in the what was then the Southern District of California, now the Central District, and that's how it wound its way from that court up to the Ninth Circuit, and then ultimately to the U.S. Supreme Court.
You know the famous line in the case that he said on the phone that was the hallmark of his betting. So you want to tell the audience what it was?
Yeah, he said, and now of course I'm going to forget it, but he said he'd take Duquesne -7 for a nickel.
Nice.
And the question was this a bet? And I think anybody who's ever gone to Vegas and placed a bet on sports knows that. The basketball team was favored, and he was betting, $500.
Do we know if Duquesne won?
That's a great question. I don't know the answer. We got to figure out.
Let's find out. Viewers, figure it out.
But he was taking tons of bets on this line, and he was calling all of his acquaintances and the people that gambled with him and the people that he placed his bets with, because he was a bookmaker. So he was placing bets on both sides of the thing, taking bets and placing them, sort of to engage in the process. And so he was literally the biggest basketball handicapper of his time.
And go ahead.
It's really striking. Olmsted was the biggest bootlegger of his time.
That's right.
So these are not small potato guys. And it's interesting that in both cases, the feds didn't take the time to get warrants because these guys were under serious enough suspicion that they might have done so, but they didn't, and they gave rise to these landmark cases.
Yeah.
I have a timeline of the events leading up to this case, and I want to walk through it so you can see how the events proceeded. So the FBI started bugging the phone booths all the way back in February of 1965 on Sunset Boulevard. And just a short time later, February 25th, 1965, Mr. Katz was arrested on 8 counts of illegally transmitting bets. At May 30th of 1965, he was convicted and fined $300. That seems pretty small, actually, for 8 counts. November 17th, 1966, Ninth Circuit Court of Appeals upholds the conviction, and March 13th, 1967, the Supreme Court decides it is actually going to hear the case. So 8 counts is a lot. If you had a client that was facing 8 federal counts, what would you say about how serious this was for him?
Well, look, I mean, they had him dead to rights. They had him on the recorder, getting on the phone, making those phone calls. So his lawyers didn't have a great. Oh no, he didn't do it. And they had the famous, Duquesne -7 line, and so there wasn't a good argument that he wasn't in fact engaging in gambling. So they had to come up with a theory of why the evidence could be introduced, and the theory was this was not that people have an expectation of privacy. When he went into that phone booth and closed that door, either he was creating a space for himself, or he had this expectation that the government couldn't surveil without a warrant, and having done so, that they couldn't use that evidence against him without a warrant.
So why would the Ninth Circuit have upheld his conviction? What was their legal reasoning?
Well, it was clearly legal under existing law. The Olmsted case said that you needed physical trespass in order to trigger the Fourth Amendment. And just as in Olmsted they put the wiretaps under a public sidewalk leading up to Olmsted's office, here it was a public phone booth in which Katz had no property interests. There was a separate jurisprudence about constitutionally protected spaces, but those were focused on things defined by property rights, like the home. So the Ninth Circuit was simply applying Chief Justice Taft's existing law, as good lower courts should, and it required a conceptual leap by Harvey Schneider and the willingness to embrace that leap by the Supreme Court in order to strike down the search.
Will you explain the process of getting from the Ninth Circuit to the Supreme Court?
Yeah, so once they got their decision from the Ninth Circuit, they had a chance to file a petition for a writ of certiorari, that is, a petition for discretionary review by the Supreme Court. In the modern era, the Supreme Court takes a very small percentage of all the cases. It typically takes cases that are of national importance or where there's a split between the circuits and some disagreement among the lower courts. In this case, the law was fairly clear, right? As Jeff has laid out, the law coming from Olmsted was clear. You had to have physical penetration. The law from Goldman, another important Supreme Court case in the space, was clear that you could use a device placed on the outside of a wall. In that case, was a detectaphone, essentially a large ear that you could sort of place up against the wall and hear through the wall. And they had essentially done this on top of the phone booth. So the law in this space was fairly clear. And so, and as far as I recall, there was not a circuit split on this question. And so, so this was a case the Supreme Court was taking in part because there was this deep concern about the modern era and the evolution of communications, and the concern that its law at the time did not address those issues effectively.
Well, what about the cooperation of the phone company? Was that a given at that time, or? Well,
this was an era, in the 1960s where, at least for the longest period, the phone companies have been pretty cooperative. As we know in this case, they'd gone to the phone company at a time, again without a warrant, and said, "Could you please put one of these booths out of order so we can place a recorder on top of the other two booths and place a microphone on each with one recorder set in the middle?" If they'd had three booths, it would have been hard to set the recorder up, and so the phone company was cooperative enough to do that. Now, they didn't go to the phone company and ask them to put a wiretap on it. I guess I'm not sure why. Maybe they were concerned about the space there, although given Olmsted, I don't think there would have been a problem.
It's true, although the wiretapping laws were just being worked out here. The Berger case in 68 gave instructions to Congress, which responded in the Wiretapping Act of 68. Yes. So the federal law may have been uncertain, and that's maybe why the phone company went along. But they were not the Apple of their day. There's no question about it. They didn't refuse to cooperate.
That's exactly right. Yeah.
And do we know anything about the Burton Marks law firm and how, what kinds of cases they took on? Did he hire high-priced representation?
Well, Marks was a famous, a defender of the accused, and so he was known for being a fierce advocate. But the interesting part is the role that his law partner played in this case, and really developing this theory and the arguments that he made, and actually his deafness on his feet before the court, I think, really brought the court around. I mean, the case was ultimately 7-1, right? Justice Marshall did not participate, but ultimately only one dissenter. So he was able to convince 7 members of the court to go along with a complete change and overruling of 2 prior big precedents.
And there was a split behind the scenes, and it was originally sort of either 5-4 or 4-4, and then Potter Stewart changed his mind in light of the argument, and that brought along the other justices, leaving only Justice Black in dissent. Unusual to see that dramatic a split, and it was because of the creative arguments of Harvey Schneider. So let's pay tribute to the great Harvey Schneider for having changed the law of the Fourth Amendment.
Well, next we're going to meet him, so how about that, and by videotape. We've mentioned that there's really very little known about Charles Katz, and one of the ideas behind this series is to tell the people's stories. And we know about the particulars of his case, but really not a whole lot about him. And next you're going to hear from Harvey Schneider talking a bit about Charles Katz, and then also our producer for this series, Nathan Hurst, on his efforts to find out more. One thing we know about Charles Katz, he paid his legal bills in cash, but we'll learn a little bit more in this next clip.
By the time we were heading back to Washington, Charlie Katz was in forma pauperis, which means he could no longer afford to pay fees. But who cares? When you get a case before the Supreme Court, you don't worry about whether your client can pay fees.
What's so interesting, though, is this is a man who had 8 felony counts against him at one point, clearly had a profile with FBI and other law enforcement. However, we cannot find a photograph of the man. It was never published in any sort of newspaper, newswire, nothing like that. There's no video of him. Even while his case was being adjudicated, he never showed up to court other than to be arraigned.
In today's age, it's pretty hard for people to disappear that completely. Does it surprise you that there's so little, not even a booking photograph of him?
It is surprising. You just think about the modern era, and a lot of this case really relates to what we're doing in the modern era. And are smartphones protected, right? Are the photographs on your phone protected from government surveillance without a warrant, or even with a warrant, under what circumstances and how you might get it? So it is amazing that sort of the progenitor of all of this discussion can't even find a photo of the guy.
We're going to move to the Supreme Court, learn about the makeup of the court and the arguments in just a few minutes, but it's time for some of your phone calls. Let's begin with Roger in Decatur, Georgia. You're on the air. Welcome.
Hi, good evening. So if you want to see a phone booth, you can go to Scott Pruitt's office. But my question is, so like Katz said that the Fourth Amendment protects people, not places, but its standard is sort of squishy because you have to decide, well, what kind of interests are protected by privacy. And so Justice Scalia in the heat sensor case said, oh, but it also protects property. Okay, so you can't go and look into the house through the heat sensor. But outside of that, there's really maybe the Keefe case, about needing a warrant for wiretaps. There's not much that says what actually is protected by privacy. And on the other hand, we have these big holes like the pen register cases that's saying that metadata can be captured, okay? And also like anything that touches a foreign border can be captured or, it's been allowed to be captured. So it seems like the Supreme Court is not really keeping up with all of the advances. We have these devices that are fake cell towers to pick up cell conversations. Policemen are scanning cell conversations when they go through neighborhoods and stuff like that, and there's no protection against that. Is there any chance? I mean, this Supreme Court is taking little tiny steps in technology areas. Any chance it will really get a solution to those kinds of problems from this court?
Great question. On the one hand, this court is inspiring and coming up with unanimous decisions, repeatedly saying that you do need warrants before you can track someone 24/7 with a GPS device or search someone's cell phone on arrest. This year, as we'll talk about later, the court will decide whether you can have 5-month surveillance of cell phones. But on the other hand, as you said so well, the word you used was squishy, and you're absolutely right. The standard the court came up with in Katz, which we'll talk more about later, that you have to have a subjective expectation of privacy that society is prepared to accept as reasonable, is squishy because people's expectation of privacy reflects the privacy that they subjectively experience. And as surveillance becomes more ubiquitous, our expectations go down along with our constitutional protections. So on the one hand, Katz was a great advance, but on the other hand, it was squishy, and the court is dealing with that squishiness, as you say, today.
Yeah, and I think that's exactly right. And at this point, in recent terms, the court decided a case about whether cell phones could be surveilled or could be searched without a warrant as part of a search incident to an arrest, and ultimately decided no. And now this term, as Jeff pointed out, the court has a case before it about GPS surveillance and long-term, cell phone locational data surveillance. And so the court is having to deal with these questions. There's a famous concurrence by Justice Sotomayor in the Jones case where she laid out the case that there are these huge issues coming up now with modern technology and that the court's going to have to grapple with them. And I think that in this very term, we're going to see the court grapple with these very difficult questions.
Our next call comes from Livonia, Michigan. Mario, you're on. Welcome.
Thank you. Was this one of the cases that fueled the impeachment drive against Earl Warren? And did that movement have any political legs at all?
That's an excellent question. I think the exclusionary rule case, MAP, was very controversial. It was a series of criminal procedure cases in the 1960s, including the Escobedo case. I remember that because when you teach Escobedo, you remember Strom Thurmond in the Supreme Court hearings of Earl Fortas to replace Chief Justice Waring saying, Escobedo, Escobedo, I want that name to ring in your ears, because Escobedo was a guy who was supposedly freed because of a constitutional technicality of the Fourth Amendment. So the Warren Court became defined by all of these criminal procedure cases that were seen as being soft on crime. I guess you could view Katz as one of those cases, and some of them gave rise to the Impeach Earl Warren billboards, which were so famous back then.
Fred is in Laguna Niguel, California. Hello, Fred.
Thank you for C-SPAN giving me the opportunity to talk. I was listening to the case of the phone booth in Sunset Boulevard, and I have a general observation on all of these cases regarding Fourth Amendment, and that's my amazement of how and why you should take the lower courts to recognize the right of the people to be safe in their persons and their papers and everything else. And it doesn't take a genius to recognize that you don't even have to do a lot of research and going from one court to another court to find out that the new technology which provides information kept on cell phones and other kind of electronic systems also goes under the Fourth Amendment. While I'm enjoying the professor's discussions, but I think we should have much more enthusiasm about going back to the right of the people. And why should it take the court to figure out if something applies or not? Because isn't it in the Constitution that even if you can't decide whether this amendment applies or not, the rest of the right of the people stay with the people? Why the courts take so long? I like to hear your enthusiasm and frustration that I have.
Thanks very much. Jamil Jaffer.
Well, I think as the caller points out, there is an amendment in the Bill of Rights that says that all the rights that are not given to the federal government are reserved to the people, to the states, and then respectively to the people. And that's an amendment that largely, hasn't been interpreted very much and hasn't been utilized, in part because there's very little detail behind it, and the court has had a hard time grappling with what that amendment means. That being said, the Fourth Amendment doctrine has changed over time. As Jeff has pointed out, this case was a landmark case because it changed the doctrine that had been in place for 40 years. And since then, Katz has really been the controlling precedent that dictates how we think about surveillance and has for the last, 40 some odd years. But there's been an interesting shift. Just recently, the court has made a move back towards a more property-based view of, at least in some surveillance cases, and has revitalized Olmstead and Goldman, even though at least the underlying principles behind Olmstead and Goldman going back to the text of the amendment. And so the question now becomes, what do you do with these cases as we go forward in the modern era? Because the reality is that the property rights approach could have some very real application. And you saw at arguments in Carpenter, Justice Gorsuch sort of talking about the way that property rights might apply in the modern era to Fourth Amendment jurisprudence.
That's such an interesting observation, and it was so fascinating, as you suggest, to see at the Carpenter oral arguments two different but supporting positions. On the one hand, Justice Gorsuch, as you said, resurrecting this property-based approach and saying that we might have a property-based interest in our cell phone records because of the contracts we have with the cell phone companies. On the other hand, Justice Sotomayor, whose important concurrence in the Jones case, which you mentioned, said that it makes no sense to say that data surrendered to a third party is one in which we have no expectation of privacy, was focused more on our privacy expectations and the fact that 24/7 searches can reveal so much about us that we should have a right to conceal our unexpressed thoughts, sensations, and emotions, sort of channeling Justice Brandeis. Yeah. So it's so interesting to see two justices from different perspectives coming to the same result by bringing together two of these threads in Fourth Amendment jurisprudence, both of which come to a head in Katz, which is why it's so exciting to talk about this tonight.
Right.
Michael is up next, Jamestown, North Carolina. Hi, Michael.
Hello.
Yes, sir, you're on. Welcome.
Oh, thank you. My question is about how the Katz case was used as a precedent in the 1979 Smith v. Maryland case, which did so much to expand electronic surveillance. Thank you.
It's great that you mentioned Smith v. Maryland. That was the core of what's called the third-party doctrine, which sounds wonky, but is the key of what Justice Sotomayor was talking about in her concurrence. The third-party doctrine says that when I surrender data to a third party, like the phone company, then I lose all expectation of privacy in it, and the phone company is allowed or can be required to turn it over to the government. Katz was the core of that case because Katz held that we only have protection in data in which we have a reasonable expectation of privacy, and Smith held that when I voluntarily surrender the information, I lose all expectation of privacy in it. Now, even at the time, Smith was controversial. It involved bank records, involved telephone records, pen registers, but Congress overturned a series of third-party cases saying it's not true that when I turn over financial records to a bank, I have no expectation of privacy in them. And Justice Sotomayor notes, in an age when all of our data is stored on third-party servers in the digital cloud, from our Word documents to our cell phone records, if Smith v. Maryland is taken seriously, it means we have no privacy today. So that's why the case is so important, why the Katz underpinning is so crucial, and why it'll be so interesting to see what the court does in the Carpenter case.
I think Jeff is exactly right. And actually, it led to, the Smith case led to all the stuff we've talked about after the Snowden disclosures and this discussion of the government's metadata program. The reason the government was able to go and obtain these large amounts of cell phone records and email records was because the court in Smith had said there's no reasonable expectation of privacy in this routing information, this dialing information, this signaling information that you give to a third party. In that case, the phone company. And in the case of the phone records, same thing. In the case of the email records, your internet service provider. And so as a result, we've had these huge programs of surveillance the government has done without warrants, under some authority, right? In that case, the 215 authority in the Patriot Act, and then in other cases, the pen registered trap and trace statute, but ultimately led to Congress changing the law in the USA Freedom Act, and has led to continued debates about whether this third-party doctrine is viable. And Justice Sotomayor's concurrence in Jones lays out the case why it's not viable. Ultimately, in that case, the court came together to decide the case in favor of Mr. Jones, who was a suspected drug dealer here in the Washington, D.C. area. But ultimately, this is the continuing debate that's taking place again here in Carpenter, and we'll see some resolution of it from the court by the end of this term.
So let's return to 1967 and the court that gave us this seminal decision. By virtue of our caller's question, we know about Earl Warren, but let's take a look at the makeup of the court. The Eisenhower appointees still serving on the court at that point: Chief Justice Earl Warren, John Marshall Harlan II, William Brennan, and Potter Stewart. Roosevelt appointees: Hugo Black and William O. Douglas. The Kennedy appointee, Byron White, and Johnson appointee, Abe Fortas and Thurgood Marshall. And as we mentioned, Thurgood Marshall did not participate in this particular decision. Explain why, please. He was Solicitor General in just before the case, and it was appointed right around the time. So maybe you can talk more generally about the Solicitor Generals and the conflict of interest that they would have.
Sure. So the Solicitor General of the United States is typically the practitioner for the government before the Supreme Court. He is the lead. He or she's the lead appellate lawyer for the government, typically. And it's their office that argues the cases before the courts. Occasionally, they'll argue cases before the courts of appeals. And really in cases of high importance to the government. And in this case, ostensibly his role, previously having served as Solicitor General, it could have been that the case was up for consideration during the petition for certiorari, and the Solicitor General's office weighed in on behalf of the United States, presumably arguing that the case should not be granted, wanted to have upheld the decision of the Ninth Circuit convicting or upholding the conviction of Mr. Katz. They obviously were unsuccessful. The case ended up coming to the court, and my guess is that's probably why he didn't participate.
You spoke earlier about the Warren Court's legacy, particularly in the areas of criminal rights. Could you talk generally about the makeup of the court and some of the alliances that had been forming over the years that the Warren Court was around?
The core of the Warren Court was the alliance between Earl Warren and William Brennan, who was Warren's deputy and helped corral majorities. Other liberals included Thurgood Marshall. Potter Stewart, as Jamil said, was viewed as a centrist who kind of liked to write narrowly and could go either way. Justice John Marshall Harlan, who wrote the concurring opinion in Katz, was really on the conservative wing, and he had dissented from several of the criminal procedure cases as well as the voting rights cases. And then there was Hugo Black, who this lone dissenter in Katz. And Black was a liberal textualist appointed by Roosevelt. He went to sleep every night reading the Constitution and burned a hole in his pillow because he would stay up communing with the original text. And he believed that no law meant no law in the First Amendment, and although he was a great civil libertarian, he couldn't bring himself to make up rights that weren't in the Constitution, and he thought that conversations were not covered by the Fourth Amendment, and for that reason he dissented.
Do you have more to say about that court?
Well, I mean, and I think he thought so because, of course, the text of the amendment doesn't mention it. It talks about persons and houses and papers and effects, and so Black was struggling with this. Said this. I might even want to consider, I might even want conversations to be covered, but they're just not there. And he was very focused on he was an absolutist, right? And he was very much focused on the text of the Constitution, couldn't bring himself to find an expansive definition in there. And so I think that was part of what was at the heart of his dissent, in this case.
In granting the writ of certiorari, the deciding to hear the case, we've learned in some of our past installments that the justices might have been looking for an excuse to revisit a certain part of law. Was that the case here? I mean, why did they take on the Katz case in the first place?
They're obviously struggling with the question of wiretapping. They're trying to translate the amendment in light of these new technologies. And I think there's an understanding that focusing on constitutionally protected places was not adequate at a time when you could invade the places virtually rather than actually. But they hadn't come up with a solution. That's why the questions they posed to the lawyers said, is it a constitutionally protected place? And why it was so significant that Justice Stewart, in his opinion, basically conceded error and said, although this is the question we asked, that's the wrong question. The real question is the Fourth Amendment protects people, not places. So you could actually see him acknowledging that the court's mind had been changed by the argument itself.
So Mr. Katz's lawyer, Harvey Schneider, was, as we've heard, up against a great deal of legal precedent as he went before the justices to make his argument. He was also an attorney without very much experience. He was only a few years out of law school. In our next clip, we're going to hear from him today, talking about his epiphany as he was thinking about the arguments he was going to make in this case, which differed from the arguments that they had set out in their writ of certiorari in the first place. We'll learn more about that from him, and then we'll also listen to a bit of the oral argument.
I'm sitting in my office one day, and I'm ruminating about Katz, probably ruminated about little else during that period of time. And I thought back to my time in law school, and in particular my course in torts. And we were taught, with regard to the tort of negligence, that negligence was doing something a reasonable man would not do, or failing to do what a reasonable man would do. We called them TARM, the average reasonable man. And then it occurred to me, we had it wrong and the court had it wrong. The inquiry ought not to be whether there was physical penetration or whether there was a constitutional protected area. The inquiry ought to be whether the person whose conversation was intercepted had a reasonable expectation of privacy. And when we got to the court in October, I violated a very significant rule of the court because you're not supposed to raise in oral argument anything that you did not brief. Well, I never briefed a reasonable expectation of privacy because I hadn't thought of it. They were really kind to me. They were listening and not interruptive because I was proposing to them a test and a solution to a problem that had vexed them for decades.
The constitutional protection would not apply, I think is the way to phrase it. I indicated this morning that we think that the right to privacy, which is the Fourth Amendment's concern as I understand it, follows the individual. And we would base our contention upon this by a reading or literal reading of the Fourth Amendment. I respectfully call the Court's attention that the Fourth Amendment, after I'm paraphrasing a little bit here, but it says that people have a right to be, quote, secure in their persons. That is the very first item of protection that is contained in the First Amendment. It says persons, Fourth Amendment. It says persons, then it says houses, and I believe it says personal effects and one other item. But it's significant to note, I think, that the very first item of protection in the Fourth Amendment is persons. And we would contend that this fact alone lends credence to our view that privacy does follow the individual.
So there's so much I want to ask both of you about that. Here we have a person who's never argued before the Supreme Court before, and you heard how he approached this and really kind of turned the thinking on its head. What's your reaction?
My reaction is that this is amazing. You know, it doesn't happen much that the court changes its mind at oral argument. It certainly doesn't happen often that the vote behind the scenes changes. And I think it almost never happens that a fundamental transformation in constitutional doctrine happens on the fly because a single lawyer has a flash of inspiration and argues it before the court, and they listen respectfully and actually embrace his suggestion. I hadn't known before learning from Landmark Cases and seeing Harvey Schneider's interview exactly how pivotal he had been. And just in real time to see the oral argument. He says, when Justice White asked me a question that seemed to suggest he was focusing on a subjective test, I responded, no, the question is it's an objective test of whether a third party would arrive at that conclusion. You're just seeing constitutional law being made in real time. This is it's unusual, it's important, and it transformed the law of the Fourth Amendment. So thank you, Susan, for having created this episode to teach us this really significant change.
And what's amazing about it is that when you look at the text of the Fourth Amendment, that conclusion is not obvious, right? A potentially more obvious explanation is what the court had adopted for the longest time, which was that persons, houses, papers, and effects were all to be read of a piece, and the persons was, you're protecting the person, the body of the person from being seized or physically searched, right? Not that persons meant the right travel with that person no matter where they were. Otherwise, if that were the case, then why list houses? Right? Houses would be surplusage. But somehow, so the most natural reading is probably not that reading, and yet in that moment of oral argument, he was able to convince a majority, a substantial majority of the court that he was exactly right. And that, I think, is really an amazing example of why oral argument is so important. You know, in the modern era, we have a lot of people, they rate how often justices ask questions, and they try to read the tea leaves about what's happening in oral argument. But the truth is, those oral arguments matter a lot because the justices prepare, they read all the cases, they read all the briefs, and when they come in with their questions, they're coming in to try and figure out where are the weak spots in the argument and what does it mean as we think about what's going forward. And so the oral arguments do matter a lot, and this is a great example of why they matter.
But he said, Harvey Schneider said that the justices listened and they did not interrupt. As you said, today, people count the number of interruptions. And in fact, I've read recently that the current Chief Justice is trying to figure out how to let the counsel at least make a little bit of their argument before they start getting peppered with questions. What do you think was going on here as a dynamic? And is the court different, or were they just so interested in this argument?
Well, I think it's a little bit of both. I mean, I think that we are in sort of an era where, at this time, where things were moving a little bit slower at the court. The justices were thinking about the issues before they were going for the questions. They may have prepared slightly differently back in this era. I think in the modern era, what you see is the justices have a lot more information at their disposal right away. They've got electronic databases of all the cases. So they're much more prepared with the entirety of, I think, the body of underlying case law, and so they're ready to come in firing, right? They're ready to sort of, I've got my 8 questions, I want to figure out what's going on and get the ball moving. I think you've seen that not just in the Supreme Court, but in the lower courts. And so we'll see if that trend continues. But I do think that might be part of it. And you know, it was just a different era, I think, in the country.
It was, and you say it so well. And there was an article in the New York Times recently about an academic study that showed that as the court and the country have become more polarized, the justices are asking more questions to each other rather than to the advocates. They're really trying to persuade each other and argue their own case, which leaves less opportunity for open-minded listening. And yet, as you suggest, it does happen. And in the Carpenter case, it was so interesting that Justice Gorsuch's really powerful questions about property rights seemed to be reflecting some recent interventions, including by Professor Will Baud at Chicago, who had written some blog entries about the property-based theory in Katz that seemed in real time to be sort of introduced in courtrooms. So maybe we'll see in Carpenter another change of mind like we saw in Katz.
And you know, over time, actually, the bench has actually changed the court. The bench used to be straight, and they actually curved the bench so the justices could almost speak to one another as they're asking questions. A lot of times, I think Jeff is exactly right, that you'll see the justices talking to one another through counsel. As they're asking questions to counsel, it's really a conversation amongst the justices at times.
So that contributes to the lots of conversation going on during oral argument. So let's listen to the argument that the government was making in Katz. It was made by John S. Martin, Jr. He was an assistant to the Solicitor General tasked with this important case. And the reason, as we said, was Thurgood Marshall, Solicitor General, was being nominated to the court. So there was a turnover in the Solicitor General's office. So we're going to listen as he is responding to questions from Justice Byron White.
We're dealing with a public phone booth. We are dealing with something different. And it's our position that even if this court were to say that public phone booth was entitled to some degree of protection under the Fourth Amendment, that it is not the same protection that comes to a house. Public phone booth is more closely analogous, we submit, to a public field, certainly, than it is to a home. And a party in a public phone booth has no right to expect that he is going to be accorded all the protections he would be in a private house. We submit that what was done here was not an indiscriminate search and seizure such as was condemned by this court in Irvine. It was it was carefully limited, one, to only involving a particular petitioner. In this case, innocent members of the public were not subject to surveillance. In only one instance which this happened, the agents testified that the tape recorder involved was a stereotype, had two tracks, A and B. They could control which conversation that they would listen to, and they did not, in fact, listen to the conversation of the innocent party.
Well, Mr. Martin, what did you seize in this fellow? You'd say this was a reasonable search of a what?
Well, what I would say that is under this court's opinion in Berger, I think the words were seized.
So the words were seized, and the admissibility of that evidence, those conversations, depend upon the reasonableness of that search. And one of the rules about reasonableness of searches under Rule 41 is you can't search for mere evidence. Do you think these words over the telephone, was a fruit or an instrumentality?
Certainly, I think in this case, they were the actual means and instrumentalities of the crime. The crime is to transport wagering information or wagers over the interstate facilities, the telephone facility.
Jamil Jaffer, would you help people decode how the justice's questions and how effectively the Solicitor General's office was answering it?
Yeah. So the hard thing about this case, one of the things we hadn't quite gotten to yet in this discussion was, can you search or seize intangible things, right? We typically think of the Fourth Amendment, or at least at that point had been thinking about the Fourth Amendment as protecting these places, places that can be searched, persons that can be seized, right? And here we're talking about conversations, and the court had just been developing this doctrine of whether you could seize out of the air, right, these words, these conversations, and whether and then the question was, okay, if you could seize these things, how do you determine whether they've been seized and what the expectation, what the privacy right is, what the right in those intangible things is? And that was the conversation that was going on between the lawyer and Justice White. Interestingly, Justice White was the justice that Justice Gorsuch clerked for when he was a law clerk on the Supreme Court. And so interesting to see how this plays out. Byron White, of course, a famous football player, Byron Whizzer White, and the courthouse that Justice Gorsuch sat in for the decade before he came to the Supreme Court was the Byron White Courthouse out there in Denver, Colorado.
It's a great connection between those two Colorado justices, and so interesting to hear Justice White ask whether this was mere evidence. There was a rule in place at the time called the mere evidence rule, dating back to the framing, which was designed to protect private diaries. You couldn't search the mere evidence where I record in my diary that I committed a crime. You could search contraband because it wasn't considered property and it was forfeited to the state. Now, the mere evidence rule was overturned soon after Katz, and reducing the protection for private diaries. But the court is struggling with John Martin to figure out whether conversations are tangible or not, whether you have a property interest or not. John Martin did a great job, incidentally. He was later appointed a federal district judge by George H.W. Bush. But Justice White has no vocabulary for figuring out exactly how to deal with it, and that's why the government is saying there's no property interest in this glass-based phone booth.
Going to return to phone calls since we're talking about the tapping of a phone booth. Next up is Tony in Brooklyn, New York. You're on the air. Welcome.
Good evening. Admittedly, I don't know a lot about law, but my question is about the Patriot Act and how it affects Katz versus United States and the Fourth Amendment in general. And could you briefly explain to a layperson what the Patriot Act is?
Sure. So the Patriot Act had a series of changes to the law enacted immediately after 9/11 in the few weeks after 9/11 that gave the government more counterterrorism authorities to conduct surveillance, among other things. I think the most relevant part of the Patriot Act to this conversation is what was known as Section 215 of the Patriot Act, and that modified an existing law about business records. And what it did was it changed that law from being about specific sets of business records and how the government could obtain them through an order from the Foreign Intelligence Surveillance Court to expand that to essentially anything that was covered by a typical subpoena. Now, the reason it's relevant, and Katz is relevant here, is because, as we talked about earlier, a follow-on case to Katz, Smith v. Maryland, determined that phone records, right, the dialing information of a phone call is not covered by the Fourth Amendment because there is no reasonable expectation of privacy under the Katz rule, information you give to a third party. And so Section 215 was utilized most famously by the government to obtain substantially all of the phone calls that took place with the carriers that were providing these orders to here in the United States in the post-9/11 era, first under a presidentially authorized program that we now know as the Stellar Wind program, and then later under Section 215 of the Patriot Act. And so the relevance here of 215 and the Patriot Act to this case is this metadata issue that goes back to Smith v. Maryland, that goes back to Katz, and it's ultimately being discussed and debated right now in the court as it was in Jones and now in this United States v. Carpenter case. So very much a live issue.
James in Greenfield, Massachusetts. Hi. Hello, James. All right, we're going to move on. Next up is Paul in White River Junction, Vermont. Hi, Paul. You're on the air. Go ahead, please, sir. Sounds like we're having a little problem with our phone, so we'll come back to that in just a couple of minutes. And we're moving on to the decision. So the decision came down on December 18th, 1967, and it was, as we said, a 7-1 decision in favor of Katz. And here's how it lined up. The Chief Justice, of course, and then a majority opinion, as we said, written by Potter Stewart, and joined by Warren, William Douglas, John Harlan, William Brennan, Whizzer White, Byron Wright, and Abe Fortas. There were 3 concurrences in the case. John Marshall Harlan wrote one separately, as did Douglas and Byron White, and then one dissent, Hugo Black. Here is a bit of an excerpt from Justice Potter Stewart's majority. Once it is recognized that the Fourth Amendment protects people and not simply areas against unreasonable searches and seizures, it becomes clear that the reach of that amendment cannot turn upon the presence or absence of a physical intrusion into any given enclosure. You were telling us earlier that there was a backstory there about alliances on that. So explain how we have 3 concurrences in this and how people decided to join in the majority opinion.
Yes, so this backstory is an account by Peter Wynn, and there was an initial split after the oral argument, 4-4, along the same lines as the certiorari vote, which would have affirmed the lower court. But 2 weeks later, Justice Stewart changed his mind and joined the justices voting to reverse. He circulated a draft opinion, which was a memorandum initially composed by Professor Lawrence Tribe, who was one of Justice Stewart's law clerks. So a shout out to Professor Tribe for this important role in the case. And Justice Stewart was influenced by the Wiretap Act, which was being debated in Congress at the time. And he was also influenced by the recent decision in the Berger case. Once Justice Stewart changed his mind, then others fell into place, Justices White and Harlan, who also changed their position. And that left Justice Black as the sole dissenter, and Justice Stewart wrote the opinion.
Going to try Paul in White River Junction, Vermont again. Paul, are you there?
Yes, can you hear me?
Yes, sir, we can. Go ahead, please.
Thanks. This is a great series. I appreciate it. 3 years after Katz in 1970, I was a graduate counselor at Kent State University, and the police budget was increased from $100,000 to $1 million a year, and we were told that one of the devices they had implemented, and I don't know if this is true or not, was a laser beam that the police could use from their cruisers to listen to student conversations. Would Katz have applied to that? Suppose I had been accused of fomenting revolution, would Katz have protected me?
Yes, it would have, because we do have an expectation of privacy that our private conversations are not being picked up by cutting-edge technologies like laser beams that no one had ever heard of before. We know that from the Kylo case, where Justice Scalia said that if cutting-edge technology is used to, in that case, invade the privacy of the home, then a warrant was presumptively required. And the Jones case suggested that even outside the home, you might have an expectation of privacy against cutting-edge technology. In the end, the government's limited in its ability to record our conversations in public by state and federal laws, but the expectation of privacy test would have protected you, I think, against the laser beam.
James in Greenfield, Massachusetts. Welcome to Landmark Cases. You're on.
Hi, Susan. Thank you. What I just wanted to say was when Justice Stewart delivered the opinion in court, he took issue with the way the petitioner had formulated their questions, which included, A, whether a public telephone booth is a constitutionally protected area, and B, whether physical penetration of a constitutionally protected area is necessary before a search and seizure can be said to be violations of the Fourth Amendment to the United States Constitution. He added a couple of words in there. One was in place of right to privacy. He added, but the protection of a person's general right. And he, anyways, that's what I had for that. Thank you.
Thank you very much. Jamil Jaffer.
Yeah, so the court was very careful, the majority, the Potter Stewart opinion was very careful to say, look, we're not opining on a general right to privacy. We're specifically talking about this phone booth. We're talking about if he closes the door and creates the space. So while it's true the Fourth Amendment protects people, not places, they were very careful to say we're not laying out a general right of privacy, and that the general right of privacy, the right to be left alone, that Brandeis had talked about in his famous dissent, was to be protected actually in the first instance by states, just like the life of a person and the liberty of a person is protected by state law. And so the Stewart opinion was very narrow, but it's important to also remember that Katz is almost never cited for the Stewart opinion. It's cited almost exclusively for the Harlan concurrence, which laid out this concept of the reasonable expectation of privacy and the idea that that was made up of two components, a subjective component, I believe that I have an expectation of privacy in this space, and then an objective component that society is willing to accept that you have, in fact, a reasonable expectation of privacy in that space. And so those two subjective and objective components, the Harlan opinion is the one that matters. And so while Stewart wrote an interestingly well-crafted opinion and one that was able to bring together these 7 members of the court, ultimately it didn't matter because the Harlan opinion is all that anybody cares about.
And here's a little bit of the text of the Harlan opinion. I join the opinion of the court which I read to hold only A, that an enclosed telephone booth is an area where a person has a constitutionally protected reasonable expectation of privacy. B, that electronic as well as physical intrusion into a place that is in this sense private may constitute a violation of the Fourth Amendment. So why is this so important?
Because, as Jamil said, it gives us a 2-part test, and lawyers love that because they can apply it. And this idea that you have to have a subjective expectation of privacy that society is prepared to accept as reasonable was clear for lower courts to apply, except that it wasn't. Because on the one hand, who knows what someone's subjective expectation is? In Katz, the guy closed the phone booth behind him, but people may have different expectations of privacy in other cases. But more significantly, the court was never systematic about measuring what expectations of privacy actually are reasonable. There's a fascinating study by Professor Slobogin of Vanderbilt. He surveyed college students and asked, what are your expectations of privacy? And he learned there was no correlation between what these students said they expected, email privacy, for example, or privacy of not having their diaries read, and the kind of interest that the court has protected. So there's a kind of let's make it up quality to the application of the Harlan test. And furthermore, it's circular for the reasons we've discussed, because it's possible for the government to lower our expectations merely by increasing surveillance. Justice Harlan himself seemed to have had second thoughts about the test. And in the White case, he embraced a more, I guess the fancy word is normative test, saying how much privacy should people in a free society be entitled to demand? And that was a far more robust test, but the majority of the court has not accepted it.
So here's a brief excerpt from Justice Black's dissent. He wrote, tapping telephone wires was, of course, an unknown possibility at the time of the Fourth Amendment was adopted. No general right is created by the amendment so as to give this court the unlimited power to hold unconstitutional everything which affects privacy. I'm thinking about that hole in the pillow getting burned for the text of the Constitution. Is there anything long-lasting about Justice Black's dissent in this case?
You know, Justice Black was fighting a noble battle. He dissented also in the Griswold case, which you've already discussed, because he didn't like the idea of the court making up privacy rights. But in the end, although he was a liberal originalist and textualist, the current originalists disagree with Justice Black. There was a great exchange between Justice Scalia and Justice Alito at the oral argument in the Jones GPS case. Scalia said, we've got to ask what the framers thought. Alito said, well, they didn't think about GPS devices. There were no GPS devices. Scalia said, yes, but there's an analog, a tiny constable hiding under a carriage at the time of the framing and eavesdropping. And Alito said, since you need 1,000 constables to get the coverage of a single GPS device, they'd have to be very small constables or a very large carriage. So here you have these two conservative justices, one an originalist, the other not, agreeing that the Fourth Amendment applied, but not for the same reason. And Justice Black there, it was toward the end of his career, was just being very rigid about, he wasn't able to see conversations as digital effects, and for that reason wrote noble, but not in the end very influential dissent.
Let's look at a couple of headlines from December 19th, 1967 on the decision in this case. The Los Angeles Times headline, Supreme Court rules bugging is subject to legal safeguards. And in the New York Times, High Court eases curbs on bugging, adds safeguard, insists police must obtain warrant to act, doesn't forbid eavesdropping. How significant, we now look at this as a landmark case, how significant was it seen in society at the time?
Well, I think it was a big deal because it really did change the law, and it also changed the law in a way that was important because at that point, you know, these devices were just coming into vogue. This was the new era of electronic surveillance, and they'd been around for a while, but this was an important way the government was collecting evidence. As we know in the modern era, I mean, it is the principal way in which the government is able to both obtain criminal evidence and, in the case of national security cases, national security evidence and information about intelligence and terrorists and operatives and the like. And so, and apparently, famously, government officials or campaign officials, as we've learned in the last few months and years, and is generated a tremendous amount of debate within the both the executive and legislative branches just in the last few months alone. This was an important case even at the time, but I don't think anybody realized how transformative it would be and how much it would influence our law. You know, even 45 years later, we're sitting here today and we're having the same 40 years later, I guess, 50 years later, having the almost exact same conversation about, okay, what does Katz mean in this context? Let's, what does reasonableness mean? Where do we look for reasonableness? Do we look to for this objective test on the second part? Do we look to the framers and what they analyzed from what they thought? Do we look to what modern law says, and do we look to the law of the state, the law of the jurisdiction in which this is happening? These are very much debates today at the court, I think, as these questions are playing out.
In a moment, we're going to hear from the young lawyer, Harvey Schneider, today, telling the story about what happened when he learned the decision. But first, let's hear from Ron in Orford, New Hampshire. Hi, Ron.
Hi. Thank you for taking the call. At the unitingamendment.com, the crowdsourced constitutional amendment, privacy was one of the things that we really struggled with trying to figure out. And we made quite a bit of progress, actually, because, privacy is an instinct. It's something that evolved through nature. And what it comes down to is not places and people. It comes down to information. If you think of it in terms of information, it's a lot easier to get your hands around. The Fourth Amendment mentions papers, and at the time that the Fourth Amendment was written, paper was the only way that information could be stored. So if the justices think of it that way in terms of papers as information, then I think it would be a lot easier for them to extrapolate what the right really means. The problem is that when that instinct is manifest in a culture, the way it manifests varies from culture to culture. So standards have to be established, and that's where the common law comes in, is establishing those standards.
Great. Thank you for that. I'm going to add one more related comment and then have you both answer. This is a tweet from Wild and Wonderful. As to the seizure of intangible things, particularly words, we should remember that the founders had gained independence from a country that would put unconvicted persons to the rack to force confessions. Perhaps they did envision protection of intangibles. So for those two viewers, what would you say?
Well, they're both really important comments, and the framers absolutely believe that we have certain natural rights that come from God or nature and not from government. And those include a kind of cognitive liberty, a privacy of our thoughts. And we know that because the great battles of the Revolution were fought over the right to make anonymous pamphlets. So the first caller is right that although the framers focused on the technology, then papers where people recorded their private thoughts and diaries, that has to be translated into a digital age. It's so interesting that your crowdsourcing amendment project is trying to come up with ways of making that clear in the amendment. I love to ask students, how would you amend the Fourth Amendment to make clear its application to digital technology? And often people will suggest adding the word digital before effects. If it clearly said the right to be secure in our digital effects, then our cell phone records and our geolocational movements would be explicitly protected.
And of course, Justice Black had his concern was, look, it wasn't like wiretapping was unknown at the framing. He said, look, wiretapping is just a modern analog to eavesdropping. And eavesdropping was well known at the framing. If they had meant to protect against eavesdropping, they would have said so. But instead, they didn't say so. They said, persons, houses,
papers
and effects, and so they didn't mean to. And so this very much that question of, do you look at just the words, or are you trying to look at what they were trying to protect as an intellectual matter, right? Was it about protecting what's in your brain and the way you translate it onto a piece of paper or the things you carry around with you? There were debates at that era of the court, and there are debates in the modern era of the court. And do you solve that by saying, well, the modern analog of papers is the iPhone, and therefore the iPhone is protected as a paper or an effect, and that's your solution? Or do you come up with a different theory of the world?
David Vincent Greco, watching us, says on Twitter, contextual dynamics was the court in a way, also essentially sending a message to Ma Bell, who along with Western Electric monopolized telephonic services and equipment at the time, and as mentioned, actually facilitated the search. Well, let's hear from Harvey Schneider, Charles Katz's lawyer, upon hearing the Supreme Court's decision.
I think the decision was December, so there was about between October and December, that's 2 or 3 months. And you just wait, and then you get in the mail. You get the decision from the court, which 7-1 we won, and it was exhilarating. The very next case that I had when I returned from arguing before the Supreme Court was representing a guy on a traffic ticket in Inglewood, California. That's going from the heights to the depths.
How human is that clip? In the McGeorge Law Review many years later, Mr. Schneider also added a postscript in his description of the case. This is what he wrote. There's a postscript to Katz which the reader might find interesting and perhaps demonstrative of human nature. When Burton Marks informed Katz of the historic decision that now bears his name, his first response was not one of thanks or gratitude. Rather, he wanted to know if he could sue the telephone company for permitting the FBI agents to put the one telephone booth out of order. And so it goes, he writes. We're going to spend our last 15 minutes talking about the consequences of Katz and its long tail. We've done a lot of that already, but let's listen to Jimmy in Athens, Georgia. Hi, Jimmy. You're on the air. Jimmy in Athens, Georgia. There you go, sir. You're on the air. Go ahead, please.
Oh, yes. I'm glad that they did increase the amount of freedom we have with this decision. But one thing they did not mention was the right to gamble. Has there ever been a case that says, hey, that law should have been unconstitutional because people have the right to gamble? Thank you.
That's really interesting. Under the old state police powers jurisprudence, you could absolutely ban things that were against public morals, ranging from gambling to cockfighting, which was deemed to lower the public morals. But Justice Kennedy's decisions recognizing a right of autonomy, a right to define your own conception of the mystery of human life, could theoretically be extended to protect a right to gamble. However, I think I'm confident in saying the court has not yet extended the right to autonomy to include a right to gamble.
I think that's exactly right.
Yeah.
So on to Katz's legacy. First of all, Charles Katz basically never heard from again. So he's faded into the history books after giving his name to this case and pursuing it to the court, which gave us this expanded view of the right to privacy. But in fact, society reacted to it, and I want to talk a little bit about that. Here's a New York Times story in December 20th, 1967. New tack in bugging, Supreme Court's ruling may produce state laws allowing eavesdropping. So I want to ask both of you, how did states respond and how did Congress respond to this ruling?
Well, so Congress, passed Title III, the Omnibus Crime and Control Act of 1968, which provided a warrant procedure for wiretaps. They created a set of predicate acts for which wiretaps could be utilized. That law has been modified over time. But Congress reacted by legalizing wiretaps for specified set of crimes. And that is the law that stayed with us. It remains the law today. It's been expanded and modified over time to give you access to different types of data at different levels of requirements, including 1986 amendments to address electronic communications and to provide additional protections. Some would say inappropriately low protections today for electronic communications. There's a big debate about whether ECPA, as it's so called, needs to be updated for the modern era. And then obviously the laws that we now see being applied today in these cell phone cases and in these metadata cases, which permit access to non-content records for something less than a warrant. And there's a big debate in the policy space as well as before the courts as to whether that's an appropriate standard or whether a warrant ought to be required for some of these non-content records where it's about your location and it could track you for weeks and days and months on end.
So we have been talking about some of the cases that came out of it. Here are a few of the key ones. In 1972, the Nixon administration challenged the Omnibus Crime Bill with a case called U.S. versus District Court. And in 2001, Kylo versus U.S. on thermal imaging, U.S. v. Jones in 2012 on the GPS tracking device, and you've both referenced the current case in Carpenter versus U.S., which will be decided later this year on the tracking of cell phone positions with the towers. So what's important to know about this series of cases?
Each is an attempt to translate the lessons of Katz in light of still new technologies. So the Keith case says there could be a national security exception to the Fourth Amendment. And if there's a real threat to national security, then maybe you could have lower standards. But generally, you do need a warrant to get records. The Kylo case involved thermal imaging that could measure the heat on the outside of a house. And a guy who was growing marijuana with heat lamps, Justice Scalia said, was protected because the technology could reveal intimate details inside the house, like the hour that the lady of the house was taking her daily sauna or bath. The Jones case has a GPS device physically affixed to the bottom of a car, and there are trespasses involved because the police walk onto the guy's driveway and seize the car when they stick the GPS device. The reason the Carpenter case is so important, it could be the most important digital privacy case of the early 21st century, because it involves the question, can the police, when we walk down the street with our cell phones, we're emitting geolocational information, and using these records, the police reconstruct a guy's movements for 127 days, for 5 months. And the question is, do we have an expectation of privacy in those records that we've emitted? The government said, no, we've voluntarily surrendered them to the phone company, invoking the third-party doctrine based on Katz. But at the oral argument, as we discussed earlier, Justice Gorsuch was focused on our property interest in the digital records, and Justice Sotomayor in the privacy expectations we have that the government's not going to be tracking our movements for 5 months and seeing the people we associate with and the rallies we attend and so forth. So what's so exciting about Carpenter, it's an opportunity for the court to do what it did in Katz and to translate the amendment with a theory that is based not in existing case law, but requires them to take an additional step. And they may do so for different reasons, but it's exciting to see justices of both sides converging around that protection.
What would you say about that list, and would you add some others to it?
Yeah, I mean, I think Keith is a particularly interesting case, and one that's near and dear to my heart because I teach national security. Keith is named Keith because at U.S. versus U.S. District Court because it involved a petition, a mandamus petition to the district court to require the judge to do something, and that it dealt with this surveillance of a gentleman, Planmandam, who was trying to blow up the local CIA office. Who knew the CIA had offices in Ann Arbor, Michigan? He was trying to blow the office up. And what the court was focused on there was this a domestic national security case or an international national security case? And the whole case decided actually in favor of, decided against the government and said this was domestic security and they should have gotten a warrant. But it's only known for its footnote, which says, we assume that in cases of national security, you may not need a warrant. And they don't even decide it. They just sort of assume it. And every court since then has held for national security surveillance, you don't need warrants, that all you need is overall reasonableness in the Fourth Amendment. And this is an interesting doctrine because this is what has developed all these cases. The entire Foreign Intelligence Surveillance Act, our entire foreign intelligence superstructure is built on the idea that you don't need a Fourth Amendment warrant. You might need something close to it or something like a Fourth Amendment warrant, but not a Fourth Amendment warrant. So it's an interesting question. I think Keith is really interesting and important, at least in the national security context, for that purpose.
Christine is watching us in Somerset, New Jersey. Hi, Christine.
Hello. My question is about expectations of privacy and whether the bar will be lowered as the younger people have less of an expectation than we do. I was born right in the middle of the baby boom in 55, and I talked to my niece, who's a millennial, about privacy, and my expectations are very high. And she laughs at me and says, look, get over it. There's no such thing as privacy. So if people in their 30s and then younger feel that there's no expectation of privacy, then where does the bar stand for what's reasonable? Thank you.
It's a crucial question. And as you suggest, if you have a test which is based on subjective expectations, if privacy expectations go down, then so do the protections. Now, it's not true that younger people have no expectations of privacy. Dana Boyd, the privacy researcher, has done some really interesting studies suggesting that millennials just have different expectations than people of our generation do. And they may be more willing to reveal themselves on Facebook, but also not so willing to be searched to the border, for example. But we can't have this show tonight without the Facebook hearings are tomorrow. And we're having a national conversation, the biggest one I've ever seen during my many years of writing and looking at privacy, about whether we trust private companies to manage data and to share it and to allow that to be governed by user agreements, which may or may not be violated. If the world is experiencing that we have no privacy on Facebook, according to the Katz doctrine, that would suggest that the constitutional protections might be diminished as well. And that reaffirms Justice Sotomayor's caution that we really may need to reconsider that subjective expectation doctrine. As important as Katz was, as great as an advance it was, it's not adequate for protecting privacy in the age of Facebook, and it will be very interesting to see what Congress, as well as the courts, come up with next.
Yeah, I think Jeff is exactly right. And I think the big question now is whether there's some irreducible minimum of privacy that has to survive even after you look at the subjective expectation of an individual and the objective views of society, and whether society as an objective matter, the sort of the common law of the founding era sets a baseline that states cannot deviate below, even if they were to permit certain types of surveillance based on the views of the community at the time. And so this is an interesting debate that I think we'll see play out here. And as you mentioned, Will Baud has written some really interesting stuff about this in the University of Chicago Law Review.
Stephen is in Weston, Connecticut. Hi, Stephen.
Oh, hi. I had a comment that I wish you would advertise this landmark series more so more people could watch it and understand that the courts have a legitimate role in making law, which apparently half the country does not understand. But my question is also a quick one. Is there any agreement as to what is an objective evidentiary standard for what society will accept as reasonable? Is it state law or court decisions or public opinion polls, or is there any agreement on anything? Because otherwise the objective standard becomes, it seems to me, sort of like a subjective standard, a shaggy dog story, as the court thinks it is shaggy, or no, I don't think that's such a shaggy dog. Anyway, thank you.
Thank you. Jamil Jaffer?
Well, it's funny. Justice Stewart, who wrote the majority opinion in this case, of course, is also the one who in Jacob Ellis v. Oregon said about pornography, I know it when I see it. And so in a lot of ways, the subjective standard, I think Jeff would probably agree with me that there is no accepted test for what is objectively determined to be what society will accept other than what the court says at the time that they think society is ready to accept. And We have seen the court, when it comes to the cruel and unusual punishment, talk about what the states are doing, and sort of taking a look at what the states and what foreign jurisdictions are doing. There's a lot of disagreement about whether they ought to be doing that, but that's at least one way the courts try to interpret certain aspects of what they think society thinks of terms of the Constitution when they're trying to apply them in the modern era. Again, hotly debated about whether that's an appropriate methodology for constitutional adjudication. But in this case, I mean, Jeff, what do you think?
No, you're absolutely right. And the lack of precise standards does make it like a shaggy dog. In the Eighth Amendment, the court might look to state constitutions or to state laws, but technology is moving so fast that often states have not passed laws regulating, for example, geolocational privacy before Congress has. There's been a bill pending in Congress that has bipartisan sponsorship that would regulate geolocational privacy. It hasn't passed yet, and not enough of the states have regulated it to give the court guidance, which makes the whole enterprise frustratingly amorphous and makes originalists and textualists like Justice Gorsuch prefer to look to property standards. And Justice Alito has said, let's look to state-based trespass rules to try to identify something objective. This is what Justice Black was upset about. And to give him his due, he was right that there's something mushy and shaggy dog-like about this reasonableness standard. And I think both sides are recognizing that it's really not satisfactory.
A historical question from a viewer on Twitter asking, do you feel that Earl Warren expanded civil rights because he felt guilty about the denial of Japanese rights during World War II when he was governor of California, and then going to D.C. to see further denial, especially to blacks? Do we know anything from his writings or his commentary about the motivation?
Well, we know that he was very upset at the end of his life about his role in the Japanese internment, and in his autobiography and revising it, he expressed regret for his role, and then he wept. However, Earl Warren was not soft on crime. Contrary to popular conception of the Warren Court and those impeach Earl Warren banners, he sided with law enforcement frequently. He was a former prosecutor and did not view this case as one that was going to thwart law enforcement, and he thought that the police could get a warrant. So I think the answer is that although he was very regretful about his role in the Japanese internment cases, it did not influence his views in these crim pro cases.
George in Pittsburgh, you're on Landmark Cases. Welcome.
Hello, thank you. I was wondering how these decisions might apply to non-government entities doing the surveillance. Recently, we've had a lot of talk about Facebook and other types of organizations doing that sort of thing.
Sure, and you're asking it on a very important week, as we noted, tomorrow and Wednesday here as you're watching this live. Mark Zuckerberg before Congress answering lots of questions about privacy.
Well, of course, the challenge is, a lot of us use Gmail, a lot of us use Facebook, Twitter, you name it. And we voluntarily give to these companies our data and a lot of access to our data. I mean, I don't know about you, but when I'm, at least back a few years ago when I used to be on Gmail, if I was looking at an email about the Bahamas, I'd get an ad for a Bahamas trip, and so I knew sort of instinctively that they may not have been reading my email, but they were certainly going through it and identifying words and pushing me ads on that basis. And so the question is, what does that do to your reasonable expectation of privacy, at least as against Google, right? Do you have one? And you have a user agreement, right? You've sort of agreed they're giving you this free account that you really want because everybody has one. And Facebook's giving you this great access to all your friends, and you know what they're doing, and you're not paying a penny for any of this. And the trade is you give them all your information, but maybe you don't really want it in the hands of Cambridge Analytica. Maybe you don't want it used to send you political messages. But you've agreed to do it, and so what's the balance here? Does Congress need to intervene and get in the game, and does the FTC need to regulate it? And these are debates we're having today, and we'll have over the next few days and weeks. And of course, the challenge, as Jeff points out, is laws are hard to change. They're sticky, and technology is moving at such a rapid rate. It's hard to imagine the government, which is so bad at technology, keeping up in its laws and regulations with modern technology and not stifling innovation. So it's a big debate.
Well, and we have just a couple of minutes, and I want to bring this all together. So it's, as you've talked about, this is evolving on so many different tracks at the same time. First of all, we have increased threats to this nation, both foreign and domestic. Technology is moving at the speed of light, and devices are coming in that we could not even imagine 2 years ago, that along with software. So we've got the commercial sphere as well. So over this course of time, do we know how important Katz is going to be?
We know that Katz will serve as an inspiration to judges and citizens to translate the protections of the amendment so we have the same amount of privacy in the age of the wires and of cell phones and of Facebook as we did at the time of the framing. As Jamil said, the amendment says Congress shall make no law. It doesn't say Mark Zuckerberg shall make no law. But it's not enough to say that simply because we sign a user agreement, then we have no privacy. And the challenge, there's not an easy answer, but I think that Congress and citizens and regulators and the Federal Trade Commission, but ultimately we the people have to be as creative as those justices were and as Harvey Schneider was. He's the hero of our show tonight. So thank you, Judge Snyder, for having challenged the court to translate the amendment in light of these new technologies. And that's what all of us have to do now that our privacy is being threatened not only by the government, but also by private actors.
So, Jamil, closing comments to you, the enduring nature of Katz. What would you say about it?
Well, it certainly is an enduring precedent, certainly does influence every debate about the Fourth Amendment and about government surveillance, whether in the national security context or in the criminal context today. It's very much a live topic, both in our political bodies, in the legislature, and frankly, between the legislative branch and the executive branch in recent weeks and months, and at the court. And so, enduring certainly to the present day. Will things change? Inevitably, the court will take up more cases and will evolve the law. Will Katz be forgotten? I highly doubt it.
We're about halfway through our series. If you've been watching with us in each one of these programs, we have said thank you to the National Constitution Center. Tonight's my opportunity to do that with the president of the National Constitution Center sitting right here. So thanks to you and your team for all of the help you've given us in this series.
Thank you for this wonderful collaboration and for educating Americans about the U.S. Constitution.
That's it for our program tonight. Thank you for being with us.
Next Monday on Landmark Cases.